Do we have any bills introductions? Senator Stephan.
I have, thank you. I have RS 2793, an act concerning childhood daycare vaccinations. It would align the exemption language with the language we passed in the special session. Thank you.
We actually have a quorum. We do not have a, is there a Democrat on WebEx? No. Senator Holscher would be the one that would be on. Okay. Well, it is 8:30, so unfortunately, we do not have a member of the minority party here, but we are at 8:30, and that is our scheduled time. So we are going to go ahead and proceed, even if they don't show up. So do we have any objections to RS 2793 being introduced? Okay, not seeing none, that is introduced. David?
Thank you, Mr. Chairman. My name is David Fye. I'm the Executive Director of the Kansas Behavioral Sciences Regulatory Board, and we would request bill introduction of a bill with the RS number RS 2636. It is a bill that affects licenses under the Behavioral Sciences Regulatory Board for addiction counselors, social work, and also other licenses under that profession.
Okay. Committee, you've heard the bill request. Are there any objections to it being introduced as a committee bill? Seeing no objections, that is introduced. Do we have any other bills to be introduced? Okay, seeing none, we're going to move right into our next order of business. We're going to open up the hearing on Senate Bill 121, updating certain provisions of the Kansas Dental Practice Act. For the bill overview, our reviser, Jenna Moyer.
Thank you, Mr. Chair, members of the committee, and I must apologize for my voice. My daughter picked up her first cold last week and practiced sharing by giving it to our whole family. This is Senate Bill 121, which I'm sure is the bill that everyone is here for. It's an act concerning the dental board, and it makes two small changes to that existing statutes of 65-1430 and 65-1467. The first in 65-1430, it's on page 1, line 28, and it states that if a licensed dentist is practicing giving dental services outside of a dental office, that the dentist should provide each patient with the dentist's name, a contact telephone number, a way to get a hold of them after hours for emergencies, and upon the patient's request, the dentist's license information. And in that second statute on page 2, line 18, it would add a provision to the Dental Practices Act that a dentist or a contract for dental services cannot require a patient to sign an agreement that would limit that patient's ability to file a complaint against the dentist board. So if you were to go get dental services, you couldn't sign any form that said, as a condition of getting services or as a condition of this contract, you can't file complaints against the dentist. And with that, I'll be happy to take any questions.
Jenna, thank you for that bill explanation. Committee, any questions? Okay, seeing none, we will now go to our first proponent, Kevin Robertson. Kevin, welcome to the committee.
Thank you, Mr. Chairman. I am Kevin Robertson, Executive Director of the Kansas Dental Association. Thank you for the opportunity to appear before you today on Senate Bill 121. The bill is, frankly, as simple as it was laid out by staff. First of all, it codifies the standard of care for orthodontic treatment by a dentist. And that's, even though we're talking about orthodontic treatment, I want to make it clear that that has to do with any and all dentists practicing in the state of Kansas. An orthodontist is a dental specialty. So that is, an orthodontist is a dentist who has first gone to dental school, then taken additional training to become an orthodontist. And any general dentist in the state of Kansas can, in fact, provide orthodontic treatment. Secondly, the bill requires that any dentist would provide contact information, emergency contact information, to their patients. So whether you're a brick and mortar building, which is now required, or you're providing care in some other manner. So if you are providing, again, some sort of mail service or direct-to-consumer service, that information still has to be provided to that patient so that they can follow up directly to a dentist if there are problems. And then lastly, it prohibits any dentist, again, any dentist, from requiring a patient to sign an agreement that eliminates their ability to file a complaint with the Kansas Dental Board. So why are we here? We're here because direct-to-consumer products in Kansas often don't do these things, all right? So we've had complaints in our dental office or at the Kansas Dental Association from dentists and from patients alike that show us that in many cases there are issues with regard to substandard care that's being offered to Kansans. Things like teeth falling out, the inability, again, to file a complaint, and the ability to come up and talk to seek emergency treatment, contact information so they can discuss these issues with their dentist. We'll hear directly from Dr. Steve Heckler, who will be testifying a little bit later in favor of Senate Bill 121. Dr. Heckler is an orthodontist in the Kansas City area. There's also, you should have written comments from Dr. Joe Moon, Dr. Ken Dillahay, and Dr. Kevin Cassidy, all orthodontists in the state of Kansas, that'll talk about their experiences, the patients that they've seen, and the troubles that they have seen expressed by their patients. So the Kansas Dental Association has received complaints directly to us. It's interesting, we're not the dental board, but we do get complaints from patients when they have issues with their dental care. That first came to our attention a couple years ago with some of the issues with regard to Smile Direct Club. Our communication with our colleagues across the country kind of revealed that that's something that's that does happen. Again, I don't want to make it sound like every Smile Direct Club patient or direct-to-consumer patient does not have access to a dentist, but we see it pretty far-reaching. So we just want to make sure that, again, that is clear, that that's something that can be done. And finally, I think perhaps even the most egregious thing that we've seen with some of these agreements that patients or clients with direct-to-consumer products have is they actually sign agreements that take away their ability, that patient's ability to file a complaint with the Kansas Dental Board. So we are codifying, again, in statute, in the Dental Practice Act, that no dentist, again, this is not just a specific niche market or anyone else, no dentist should or can have the ability to have a patient sign an agreement that does that. Now, whether or not that may or may not have been legal if challenged, I don't know. But the fact is that that should not be something that any dentist should be able to do. So that is in Section 3 of the bill. And I want to conclude my comments today just by saying that it's not our intent to try to eliminate any type of niche market, any type of innovative dental care, but it is our strong desire with the Kansas Dental Association to make sure that standard of care, the public health and safety, is recognized regarding what type of care, what your treatment options might be with regarding your dental care. So with that, I do believe there's room for both, again, niche market dentistry or direct-to-consumer marketing and standard traditional dental offices to work together and be able to work together in the state of Kansas. But we believe strongly that this bill would help the public health and safety. With that, I'll stand for questions whenever you have that open.
Kevin, thank you. We are going to hold until after all proponents have testified. Committee, our next proponent is virtual, Gianna Naraki. Gianna, are you with us?
Yes, thank you, Chairman.
Welcome to the committee.
Thank you. And thank you for having me virtually today. So good morning, Chairman and committee, and thank you for the opportunity again. My name is Gianna Naraki. I'm the Government Affairs Associate at the American Association of Orthodontists. I'm speaking today on behalf of our 19,000 members, but more specifically on behalf of the Kansas Association of Orthodontists and its 105 members throughout Kansas in support of Senate Bill 121. Telehealth is becoming increasingly used in providing dental services to patients. As such, it is just as important that telehealth is being provided in a way that is safest for patients. The AAO supports legislation that it believes will best protect patient health and safety, regardless of the modality, and we believe that that is accomplished with Senate Bill 121. Orthodontic treatment is a complex biological process and not just a cosmetic procedure. The complexity of the process of moving teeth requires a trained orthodontist or dentist to have all the necessary information at their disposal, which can only be gained through a physical examination before starting treatment. Our members are using technology every day to make treatment more convenient for their patients and to embrace technology. However, they're able to do that because they have a physical exam of their patients and gather that information in order to also use telehealth during their treatment. SB 121 highlights the standard of care that applies to all Kansas licensed dentists, and it does not hinder the ability of a Kansas orthodontist or dentist to provide orthodontic treatment to patients, nor does it restrict their ability to make decisions as the treating provider about treatment plans for their patients. Senate Bill 121 also ensures that patients are aware of who their treating dentist is at all times, again, regardless of modality. This provision creates a parity. A patient receiving care in a dental office is provided this information, so it is important that when telehealth is used, the patient also has this basic information about their dental provider. Under the Dental Practice Acts of Kansas and every other state, state dental boards are the primary state entity with jurisdiction over enforcing the laws governing dental practice. When patients are required to sign an agreement waiving their ability to file a dental board complaint, they lose the ability to contact the board with primary jurisdiction over their problems. Providers should not be permitted to sidestep the enforcement authority of the dental board by requiring these contract provisions from patients, and SB 121 would serve to end this practice. In summary, the AAO and the KAO believe that Senate Bill 121 allows telehealth advancements to continue to grow in Kansas in a thoughtful way, while still maintaining a standard of care that is the best interest of the health and safety of Kansas patients. This bill allows Kansas patients to utilize telehealth without forgoing their right to know who their dentist is and their right to seek assistance from the Kansas Dental Board. Additionally, this bill maintains a standard of care for all dentists regardless of the modality being used. As members of this committee, if you have any additional questions or would like to review the scientific research about the standard of care for orthodontic treatment, please visit orthofacts.org, and we are always willing to answer questions and provide evidence-based resources for patient health and safety in Kansas. Thank you for your time and your continued work on behalf of Kansas citizens.
Gianna, thank you very much. Committee, next is Dr. Stephen Heckler with us virtually. Dr. Heckler, welcome to the committee.
Thank you. Thank you. Well, as Kevin told you, I'm Stephen Heckler, an orthodontist in Overland Park, Kansas, speaking in support of Senate Bill 121. Mr. Chairman and committee members, thank you for giving me the opportunity to take some time to go over some items with you, and I'll read a prepared statement and then be happy to answer questions in the future here. My background includes undergraduate studies at the University of Missouri-Columbia prior to obtaining my dental degree after 4 years at UMKC School of Dentistry. I then pursued a 36-month training residency program at the Mayo Clinic in Rochester, Minnesota, obtaining a certificate in orthodontics and master's degree. Kansas Dental Association has allowed me in the past to serve in a number of officer positions, ending as president. I've had the great fortune of practicing orthodontics in Kansas as a board-certified orthodontist, 35 years, and I'm a member of the American Association of Orthodontists, College of Diplomats of the American Board of Orthodontists, American Dental Association, Kansas Dental Association, and past president of the Kansas Association of Orthodontists. My orthodontist colleagues in Kansas feel that the patients of Kansas deserve an expected standard of care when considering orthodontic tooth treatment. Careful examination, professional diagnosis supply an important beginning of their journey for a healthy, thick smile life. This requires not only a thorough examination performed personally by the dental professional, but current radiographs be certain very stomach bone disease, or tooth root resorption, which is shortening of the root. All these may affect or negate the possibility of starting. Any of these issues can be tooth during, after. A good number of Invisalign type patients have been
Dr.
previously.
Heckler, I apologize to cut in, but you sound like a parent off of the Peanuts cartoon. I'm not sure if your feed is allowing you to carry video and audio at the same time. You might cut your audio or your video and just try your audio for a little while, see if that helps.
Okay, let's try that.
Thank you.
Would you like me to repeat anything?
No. Please proceed.
Okay. So a good number of the Invisalign type patients that have previously been treated by braces when younger did not comply with the suggested retainer wear. These patients have no current radiographs displaying the occasional significantly shortened roots, that root resorption we talked about, from that stent of braces. Further tooth movement can lead to loss of teeth. My personal experience with do-it-yourself home treatment patients is that they are younger adults who have been promised a less expensive way to regain straight teeth. They're never turned away by the commercial companies, and we turn away about 50% of those who request Invisalign type of treatment in our office. I use Invisalign just as an example, not that brand. And some of those who later make their way to our office are very disappointed with their do-it-yourself experience. Periodic ongoing appointments during treatment at the dentist or orthodontist office are needed to monitor the progress and make sure none of the above mentioned problems arise during treatment. Drinking soda and sports drinks while wearing these type of orthodontic tray can lead to demineralization and discoloration of tooth enamel that can result in tooth decay. Rarely during orthodontic tooth, excessive movement of the teeth can lead to loss of bone and gum tissue that can be irreversible. The standard of care in our profession is to take a few radiographs and photographs along with retainer observation after the treatment is completed. This observation lasts for months or years after treatment, periodically being seen in our office. With no dental professional on board, do-it-yourself home treatment, there's no way for Kansas patients to know that disease or trouble is present. Having a personal responsibility to our patients by being available for urgent or emergency questions, along with the Kansas Dental Board required displaying of our professional licenses, gives Kansans peace of mind in knowing a trained professional is on their side. No Kansas patient should be required to sign off on their legal ability to licensed professional to a standard of care expected of their dentist or orthodontist by the Kansas Dental Board, as in some agreements with the above mentioned treatment. The patients have no orthodontic training or knowledge. Thus, the state legislature has a dental charged with responsibility. For these reasons, I and my colleague would highly recommend that you consider passing Senate Bill 121 to help protect the dental health of Kansas citizens. Thank you very much.
Dr. Heckler, thank you for your testimony. Committee, this does conclude our proponent oral testimony. I would direct your attention to your packets or online. You do have 4 pieces of written only testimony. Committee, do we have any questions for any of the proponents? Okay. Senator Gossage.
Thank you so much for being here. I am trying to access the information online, and for whatever reason, I'm not able to get the internet. So I've been trying to fiddle with that. But did listen to the testimony and will definitely read through everything. And it was hard to hear some of the online statements, but if I could have the gentleman, could you come up to the microphone, please, if it's okay with you, Mr. Chair? So you said that there were some people saying they had teeth falling out?
Yeah, Dr. Heckler really would be a better person to answer that question because he has seen some of that in his office. And I know Dr. Heckler was not very, obviously we couldn't hear him very well. So I'm is he still online? I don't know if it's something.
Dr. Heckler, are you still with us?
Yes, I am.
Did you hear the question from Senator Gossage?
Yes,
Would you like to answer that, please?
the situation that we look for as orthodontists in making sure that teeth do not become loose and fall out or become so loose that they're useless is they're looking for the length of the roots, which can shorten during orthodontic treatment. And that's why when we look at retreating someone, the first thing an orthodontist will look at is what is the root structure. The other thing is supporting bone and gum around those teeth. Is it still strong, or has it decreased to where it again makes it such that we shouldn't attempt to move those teeth for fear that they may become loose, unusable, or as Kevin said, possibly even be lost. One of the things we look so carefully about is to make sure we never get into a case of tooth movement that we would lose teeth. So I have never had a tooth fall out during orthodontic treatment, because if one does get that loose, we stop treatment at that point.
Thank you. And two other questions, if I may, Mr. Chair. Okay. We know that there was a lot of controversy when telehealth first came available, and now it's an accepted practice. One of the things was, well, they don't have an in-person exam. So I'm just curious about how you may see a relationship between these online providers. I'm not exactly sure how to, what's the word that you used?
Well, teledentistry, direct-to-consumer products.
Direct-to-consumer, thank you. The direct-to-consumer products, and then the dental orthodontist in their office. How do you see this relationship working together?
Well, I think that'd be a better question maybe for the people, the other folks that are going to testify. So I guess to clarify, so yes, this is a, quote, a telehealth product that's being delivered. However, in the state of Kansas, we do not have a teledentistry statute, or dentistry is not included in the telehealth statute, however you want to look at that. Now, last session, there was an emergency order, or, through COVID, that did allow some patient treatment through telehealth. Just exams and whatever, while the dental offices were shut down. So right now, that does not exist. So short of that, that is a difficult question to answer. Is it somewhere we need to go as a state? Perhaps. I will tell you, I think it was 2018 when the original telehealth statute was put in place. That was something we supported. At that time, the powers that be felt that dentistry did not need to be included in that particular statute. So that's kind of where we are. The dental board has ruled on that on more than one occasion, that telehealth is not allowed or acceptable in Kansas. So that's kind of where some of this dilemma is with the way this treatment's being provided.
So and last question, if the individual were to go in, or how these work, and we'll find out more when the opponents, I'm sure, testify. If an individual decides to fill out the information, the application, we'll find out more about that. But if it's not in person, how could this X-ray be done? Are you suggesting that the individual go to an orthodontist?
Yeah, I mean, I think there's a couple ways that could happen, particularly with a teledentistry model. I mean, there's nothing in the law that says, or what we're saying, that the treating orthodontist has to provide that X-ray. So, and I know in some of the agreements that, again, using Smile Direct Club as an example, they do have language that the patient signs off on that, hey, I've been to a dentist. So they're trying to, cover themselves that way by saying that this patient has come to me and agreed that they've been to a dentist or verified that. So that treating general dentist could provide the X-rays, or they could seek those X-rays out through their treating general dentist, as long as they're within 6 months and they're recent X-rays, and then from there go ahead and continue the diagnosis that way. So, I mean, I think that's one way it could work with a telehealth model. And using actual live X-rays, to be delivered by someone else other than, again, a treating orthodontist who might be somewhere virtually, so to speak. But that was something I think that they'd have to work out with that. But I think it is doable.
And they would give these X-rays to this other dentist or to the individual?
Again, I don't know the answer to that. It could be, I suppose, either way.
Thank you. Thank you, Mr. Chair.
Senator Erickson.
Thank you, Mr. Chair. Just two quick questions. And Kevin, thank you for being here. Of course, we want to make sure that we don't jeopardize patient care, whatever the outcome. Following up on Senator Gossage's question, it made me think, so the X-ray requirement, would that be the same if a patient were going from one in-person brick and mortar orthodontist to another one? Would they have the same requirement to provide that X-ray, or is that only if it's direct to consumer?
No, the X-ray requirement would be true of any and all dentists providing orthodontic treatment. So brick and mortar, any type, however that might be done, as long as the X-ray does have to be recent. So let's say I've been to one orthodontist and I went to a second one. The second orthodontist is going to have to take either X-rays again, or if it's more recent, they're going to have to request the charts, which happens all the time, the charts and patient records for that patient from that first orthodontist.
Real quick, is there any other area of dentistry where it's required that a certain set of X-rays or exam be done? Is that anywhere else mandated, or is that left?
Yeah, generally the standard of care is mandated by the dental board, or certainly through dental education. The issue, to some degree, with why we're here, as opposed to, say, the Kansas Dental Board being able to look at some of these issues, has to do with some antitrust issues. There was a case in North Carolina. Actually, Lane Hemsley with the Kansas Dental Boards here might be able to address this if you're interested. But so the dental boards around the country have been a little bit hesitant to jump into some of this direct-to-consumer care with with opinions on that. So North Carolina Dental Board is different than the Kansas Dental Board, but there is some reluctance to take any action against some of these players without legislation.
Thank you. And Mr. Chair, just one quick, if I may.
Please, because we are running.
Okay.
We do have a committee after us, so we only have this room till 9 or 8:50. So, or, I'm sorry, 9:20. Sorry. Every chair has to figure out what time zone we're in and where we're at. So I apologize. It's 9:20 is all we have. So please proceed.
Okay, my final question is, in the bill, it says a dentist or contract for dental services should not require a patient to sign an agreement that attempts to limit that. Has that been happening? That's concerning if that's been happening. So
It has been happening, again, with at least one of these particular direct-to-consumer companies. So whether or not they've changed that agreement or not, I mean, it was one of those issues that came to our attention, and no one should have the ability to do that. No dentist should have the ability to do that. So again, the statute, Senate Bill 121, what we're saying is no dentist should have the ability to take that right or have a patient sign an agreement that takes that right away from them.
Thank you, Mr. Chair.
Senator Baumgartner.
Thank you very much, Mr. Chair, and thank you, Kevin, for being here. Two quick questions. Is the Kansas Dental Board, Kansas Dental Association involved in any interstate compacts?
Well, certainly Kansas Dental Association is not.
Board,
I would suspect Lane's here, but I would suspect the board is not either.
okay. So there are no interstate compacts right now for dentists?
No.
Okay. Last question is, Delta Dental is a major provider in the state. So where are they on this issue? Would they cover ortho care if there hadn't been x-rays within 6 months, 12 months period?
To be quite honest, I don't know if a direct-to-consumer type product delivered to a patient is covered at all by insurance, but I'm looking around for a Delta rep.
Yeah, and I don't see it.
Yeah, and I don't know the answer, but that's certainly something I can come up with an answer.
I think it would be helpful if we
Yeah.
had that background information, because Delta does provide so much coverage for the state of Kansas, including employees of the state of Kansas.
Yeah, and x-rays themselves, again, for orthodontic treatment are the standard of care. So if a dentist, if an orthodontist were to treat a patient and have issues, that would in fact come before the Kansas Dental Board. That wouldn't be no question that that'd be an issue.
Thank you, Mr. Chair.
Committee, I do not see any further questions. Kevin, if we strike that first section, will you guys still support the bill?
I don't know the answer to that question.
Because I will tell
Chairman
you.
Hildebrand? Yeah, but we're always available and we'll work how we need to work.
I will tell you that as the chair, that gives me heartburn to mandate x-rays on somebody, so Committee, next, we do not have any more proponents, so we'll move right into opponent testimony. Dr. Jeffrey Solitzer, Chief Clinical Office, Smile Direct Club. Dr. Solitzer, welcome to the committee.
Thank you, Chairman, members of the committee. My name is Dr. Jeffrey Solitzer. I'm the Chief Clinical Officer at Smile Direct Club. I've been working for the company for 5 years. I am a general dentist. I've been a dentist for 37 years. I'm going to try to be as brief as I can. I just want to call out that our opposition to 121 is clearly based on the mandate for X-rays. It's curious to note that there is absolutely no other legislation that mandates X-rays in the dental field anywhere in the country that calls it out specifically. And interesting to note that of all services, why are we not mandating X-rays for oral surgery, where patients are having their teeth extracted, there's bloodletting, there's an opportunity to damage nerves, placement of dental implants, which is a highly aggressive oral surgical procedure that's being conducted, is not mandating X-rays. There's no legislation that mandates X-rays for root canals and so on, periodontal surgery. So why would you offer a language to mandate X-rays for a service such as orthodontics, which is less invasive, significantly less invasive than oral surgery, gum surgery, and other dental procedures? So it just doesn't make any sense clinically. I also want to call out that the FDA and American Dental Association, and by proxy, the Kansas Dental Association put out guidelines in 2012 for dental X-ray use by dental providers. And those guidelines clearly state you cannot have a standing order of X-rays for every patient in your dental practice. The providers, the dentists, and other dental specialists, and that includes orthodontists, oral surgeons, and the like, are not supposed to order a standard X-ray. So in other words, I cannot have one type of X-ray for every patient that walks in the door, so the staff takes those X-rays. The diagnosis must be done individually based on the patient's clinical presentation at the time of treatment. So there's an individual X-ray treatment plan, if you will. So ordering or mandating X-rays for patients who are going to have mild to moderate crowding and spacing addressed for every patient that walks in the door is an egregious overuse, and it is in violation of the FDA and ADA, American Dental Association, and Kansas Dental Association guidelines to dentists. There is an acronym called ALARA, and it means as low as reasonably achievable. And in essence, what it means is that you take X-rays if and only if there is a diagnostic and treatment advantage to take those X-rays. And that's not for each and every patient. And I want to call out specifically that if our affiliated Kansas licensed dentists and orthodontists who use the teledentistry platform feel they need X-rays, they will order X-rays, but only after they analyze and review the patient's specific dental history, their medical history, and take all those issues into account, and then we'll order the specific X-ray. By the way, I do want to call out that we are in support of the second paragraph, where we believe that patients should know who their treating doctor is. It's a prescription product. They know who their treating doctor is. They should have access to their treating doctor, and the patient should always have the right to complain to a dental board if they feel something has happened to them that has been beyond the standard of care, or they've been harmed in any way. We have no documents that prevent a patient from going to the dental board. And speaking of those complaints that we have supposedly been exposed to, oftentimes, and we see this throughout the country, that when you ask specifics about, well, who actually had their teeth fall out, who actually had trouble or problems, they go to anecdotal data, and they don't give you the patient's specific names. We've treated over 8,500. When I say we, I mean the Kansas-affiliated orthodontists and dentists that are licensed in Kansas have treated over 8,500 patients in Kansas over the past 7 years, which amounted to a savings over $33 million for those patients. And what that calculation is basically brought together by the fact that our affiliated doctors charge around $2,000, and the local dentists in Kansas and orthodontists will charge $6,000 plus. So it's 60% less through this teledentistry platform. So we're saving Kansas residents significant amounts of money. And the also other thing I want to call out as well is that there is additional written testimony here from the American Teledentistry Association, the American Telemedicine Association, and TechNet. And also, I want to call this out too, because when we talk to direct-to-consumer, it's really, by far, you need to understand, it is still following the standard of care in orthodontics. There is a dentist who prescribes the care, manages the care, and directs the care throughout the entire treatment plan for that patient all the way into retention. And I also want to call out that of the 105 Kansas counties in Kansas, only 18 counties have orthodontists present in those counties. So there is clearly a manpower shortage area for orthodontics. And you might say, well, it's only orthodontics, it's for cosmetics, but it's beyond that. It's also better for periodontal conditions, for self-esteem, for jobs and personal relationships. I think I'll stop there in the interest of time, but thank you for your time, and I can address any questions if any.
Dr. Solitzer, appreciate it. And congratulations, you're the only opponent testifying, so you get all the questions. Committee, Senator Petty.
Thank you, Mr. Chairman. And when I originally, you were listed as written only, so it was fortunate to see that you were testifying. So you mentioned that you do support Section 2 of the bill, which talks about the license visibility. Is that correct?
Correct.
And what about Section 3, the addition of letter B, cannot limit the ability to complain to the Kansas Dental
We do support that, correct.
Board as well. And then, so it appears in the biggest, I mean, well, it's the elephant in the room on the bill, but concerning x-rays. And so your position is that nowhere else in any kind of other dental procedure are x-rays spoken to in legislation. So why would we have that in this particular bill? Is that correct?
That is correct, and also why orthodontics? I mean, if you want to introduce that, you would target aggressive surgeries like implant placement surgeries, or other oral surgical procedures and the like that are.
So it's interesting. I mean, I haven't had the procedure done, but I actually had gone to a dentist, orthodontist, to investigate this actually prior to the session and prior to even knowing about this legislation. So I understand the costs that you're talking about. And then I started getting, it was interesting because then I started getting Smile Direct emails, which, you know, everybody in this room probably knows, do you think, how did these emails pop up in my email box? But I thought that when I looked at the Smile Direct, and I'm sorry for using a specific name, but that's who I was getting from, when I noticed that, and I thought, oh, this is interesting, you know, I don't have to go to somebody, but I thought for sure that it was required that I had to have x-rays, that I had to submit x-rays in order to be able to get the materials for the inline procedure.
X-rays are not required. X-rays are utilized depending upon the Kansas licensed dentist or orthodontist who's treating that patient. If they believe they need X-rays in that particular case, they will order X-rays. They can either obtain them from the general dentist or send the patient out to get them taken somewhere else if they need to. But not every case requires X-rays, but when they are indicated, the doctor will order them.
And would those x-rays be expected to be done in the last 6 months, as is mentioned in the bill?
That's probably what would be it's best for the patient. But one thing that hasn't been addressed by the proponents or myself yet, and I need to call this out, is that x-rays are detrimental to your health, right? There's a cumulative effect of x-rays. So you might say, well, it's just one more x-ray, why not take it? The real question is what kind of x-ray? As I mentioned, there are 4 to 5 different types of x-rays that can be taken in an orthodontic office, all used for different purposes. So what I'm getting at is we don't require x-rays, our treating doctors do not, unless they believe there's a diagnostic and treatment advantage to obtaining that x-ray because we don't want to put patients' health at risk.
Thank you.
Senator Gossage.
Thank you very much. A couple of quick questions. So do you take all people that apply, or so they fill out an just want to walk through the steps. They fill out an application, have to answer these questions. If they say, for example, I have periodontal disease, would you take them?
Well, again, it would be the Kansas treating doctor who would make that decision. That doctor would make that decision, and not all cases are accepted. That is correct. They are not. If somebody presented with evidence of periodontal disease, that patient would be referred out to their local dentist, what's called a periodontal clearance, and they would be expected to have that periodontal treatment done before they can be treated for orthodontics. So yes.
Thank you. And then, so then you mentioned earlier you take patients that have mild to moderate, need mild to moderate adjustment. And how many, you said 8,500 in Kansas, how many in the United States?
We treated over 1.5 million worldwide. We also are international, so we have affiliated doctors in the UK, Australia, and so on. So of a total, it's actually probably more like 1.6 million patients have been
If
treated.
somebody did have a complaint, where would they go?
Well, it depends upon the jurisdiction. They would likely go to their dental board is where they go if there's a problem, as they would, by the way, in a traditional orthodontic setting. Please understand that orthodontic complaints do arise in the traditional setting. And we do expect, and you do see, patients going to the Kansas Dental Board complaining about the orthodontics that was delivered in a traditional setting as well. These things happen, and an investigation is ordered as appropriate, which is the way it should be.
There was a mention, my last question, there was a mention about drinking soda, and then, you know, and you have these, but I know, the reason I'm saying this is just like Senator Petty, I looked into this for myself and have considered it. And I'm wondering if, what I read was that, you know, you shouldn't, if you're going to drink any soda, braces or not, you should go in, and I had 2 children who wore braces, one for 5 years. They drank soda, they had to go in immediately and brush their teeth. I mean, even if it sits on their teeth with their braces, they would have an issue, correct?
Correct, that is correct. And what's nice about the model that we are talking about through Smile Direct Club and other aligner companies, the best news is that you can take those aligners out, you can drink a beverage, you can eat a meal, provide your oral hygiene, brush your teeth, floss your teeth, and then put them back in. With traditional braces, you can't do that.
Thank you very much. Thank you, Mr. Chair.
Okay, committee, not seeing any further questions. Doctor, thank you very much. Committee, we do have the 3 other opponent testimony. We do not have any neutral. So with that, we are closing the hearing on Senate Bill 121. We're going to move to the next order of business, and I do have to let you know, technically, this is still considered an informational hearing because Senate Bill 381 has not officially been designated, sent to our committee. The bill has been read in, but it has not been assigned yet, and we do anticipate that being assigned today. So today is technically informational. Hopefully tomorrow will be official hearing. So with that, Jenna Moyer will give us an overview on Senate Bill 381.
Excuse me. Thank you, Mr. Chair, members of the committee. Senate Bill 381 is related to the authorizing and prescribing of prescription drugs for off-label use to treat COVID-19. I'll first start off with 2 definitions. And the first is that of a prescriber, which is defined in this bill. All the definitions will be on the second page. And a prescriber will be either a physician, a nurse midwife, a registered nurse practitioner, or a physician's assistant that has one of those collaborative practice agreements. And a pharmacist is a person licensed to practice pharmacy in this state. And this bill states that a prescriber may prescribe, so one of those professions may prescribe, and then a pharmacist shall dispense. And the shall here would take away the discretion that pharmacists typically have through KSA 65-1637N, their discretion not to fill a prescription if it's in their judgment or discretion that it should not be filled. So the prescriber may prescribe, and then a pharmacist shall dispense. if there is a prescription order, a prescription drug, and this drug would have to be approved by the FDA, and it would include, but not be limited to, those drugs of hydroxychloroquine sulfate and ivermectin for an off-label use to prevent or treat COVID-19 infection in a patient. And the provisions in this paragraph would not apply to controlled substances, and those are the controlled substances described in the Criminal Code and KSA 215705, which would include things like opiates, stimulants, steroids, et cetera, the things that you wouldn't want prescribed just to anyone for any reason. Those addictive and possibly dangerous medications would not be allowed to be prescribed under this bill. And paragraph 2 says that a pharmacist may prescribe and a prescriber may prescribe and a pharmacist shall dispense a prescription drug pursuant to this section, even if the patient has not been exposed to or tested positive for COVID-19. Subsection B begins on line 17, and it would create immunity for civil liability for damages, administrative fines, or penalties for the healthcare decisions, acts, or failure to acts rendering healthcare services if the prescriber or pharmacist is acting pursuant to this section. So if you're following the provisions of subsection A, then you would be immune from civil liability or damages, and any action taken by a prescriber or pharmacist pursuant to this subsection shall not be considered unprofessional conduct. And unprofessional conduct is defined on the second page. It's the last definition, and that would include professional incompetency and unprofessional conduct in the pharmacy statutes, the physicians, the nurse practitioner statute, as well as the physician statutes. And then this paragraph 2A would say that a recommendation, prescription, use, or opinion for COVID-19, including a treatment not recognized by the licensing board of those professions or the KDHE or the FDA, could not be considered, again, unprofessional conduct as defined in this bill. And the provisions of this paragraph would apply retroactively to any disciplinary action accruing on or after March 12, 2020, which is when the state of emergency concerning the pandemic was declared in Kansas. And the subparagraph B would state that the licensing boards for prescribers and pharmacists would be required to independently review all disciplinary actions for acts accruing from that March 12, 2020 until the effective date of this section. So those boards would have to go back and look at all those cases of disciplinary action. And if action was taken based on conduct described in this paragraph, so if there were if someone were to have prescribed one of these medications and were to have received disciplinary action after March 2020, before today, that the board would have to go back, open that case up, and reconsider such action and rescind any disciplinary action that would be prohibited by this bill. And then subsection C is all the definitions. It defines COVID-19, defines disciplinary action, which we've already went over, and off-label use. It means prescribing prescription drugs and treatments other than those that are approved by the FDA, pharmacist, prescriber, we've already went over, as well as unprofessional conduct. And in section 2, it states that this would take effect in the Kansas Register, which would be slightly faster than the normal statute book. And I'll be happy to answer any questions.
Jenna, thank you. Committee, do we have any questions for Jenna? Senator Petty.
Thank you, Mr. Chairman. So, Jenna, in section 1, you mentioned that the prescriber may prescribe and the pharmacist shall dispense. So the key word here is shall, because they no longer have, so that they can't, the pharmacist can't
They could not refuse.
Not refuse. Is there, so does this then, through, as it goes on to the last section of the bill on disciplinary action, does that then in any way pertain to if the pharmacist still will not fill the bill, fill the prescription? Does this pertain to them at all, or is there punitive action there?
This bill would not protect a pharmacist who refuses to fill, because this bill requires, it mandates, it takes away the discretion to not fill a prescription. So if there were to be a disciplinary action, this bill would not have any, it wouldn't prevent that disciplinary action from going forward.
And there could be, okay, thank you. All right.
Senator Stephan.
Thank you. The pharmacists have the responsibility to validate, verify, and authenticate prescriptions. That wouldn't be changed by this bill, correct?
Yes. So before, in the 65-1637, there is a requirement for pharmacists to authenticate a prescription, make sure that, like if a dosage were inappropriate for someone's body weight, perhaps if they were given, 10 times the dosage, that could be harmful, they could not fill it. But the subsection N is the discretion if it's not within their judgment or their professional judgment, saying, I don't think this is a good idea. So they would be allowed to not fill it if it were, potentially an inappropriate, I don't know all the pharmacists' reasons why they may not fill it, but they're allowed to authenticate it. But if in their professional judgment, they disagreed with it, perhaps they would still be required to fill it.
Senator Baumgartner.
Thank you, Mr. Chair. Thank you, Jenna. Is Senate Bill 381 modeled after any legislation that's been passed or introduced in any other states that you know of?
There are several other state legislators that have introduced this legislation. I'm not aware of it being passed anywhere. You could look to Colorado and Pennsylvania that have introduced legislation that would have a similar format to this.
I heard Nebraska, so we'll check that. Thank you.
Senator Holscher.
Thank you, Mr. Chair. Jenna, can you tell me, is there anything in the bill that requires some type of communication from the healthcare provider or the pharmacist, basically indicating that this is what is considered an off-label drug?
There's not a specific requirement in this statute, although there would be the general requirements of a physician to make sure that the patient understands and gets that consent from the patient.
Okay.
Senator Stephan.
Is there any requirement in Kansas statute anywhere that any other medication used off-label is required to be designated as such?
Thank you, Mr. Chair. I'm not aware of any other, like in writing requirements for specific medications. There may be some related to abortifacients, but I'd have to look into that.
Okay, I don't think there is. 20% of all prescriptions are FDA-approved drugs for off-label uses, so this is anything but unique.
Committee, I do not see any further questions. It is 9:23. We are 3 minutes past our allotted time in this room. I do apologize. Unfortunately, we are running out of time on this. Our committee tomorrow, we do have a hearing scheduled all day tomorrow as well.
Excuse me, we have doctors here who had to cancel their patients today to be here. I don't know if they can come back tomorrow.
Okay, well,
Care about their patients.
ma'am, I do care about that, but unfortunately, there is another meeting here right after ours. I did put out the schedule that this was going to be after the hearing that we had today. That would be a partial, but we have all day tomorrow cut out. I am not sure why today was the day that everybody decided to testify, because we have all day tomorrow to testify. I do apologize. Unfortunately, we are out of time, so. Let's, yes, you are on, and if you cannot come in person, you can testify via WebEx or virtually, so.
Mr. Chair,
8:30.
it's not,
Senator Baumgartner.
Mr. Chair. Excuse me,
We're
trying to get clarification here. It's not all day tomorrow, it is just tomorrow.
just tomorrow morning. I'm sorry, all meeting day. Thank you for the clarification. So for 50 minutes. So with that, we're adjourned. Thank you.